Welcome to this unit on data control and protection. By the end of this unit, you will be able to describe issues of data governance and data protection. Data protection. From a human rights perspective, an individual should always control his or her personal data. Control may include various approaches to individual consent, mechanisms to ensure that third parties use data appropriately. The state is the ultimate guarantor of the individual's right to privacy, and data protection laws are rights-based approaches. Data protection laws include standards for the regulation of data processing activities that both protect the rights of individuals and establish obligations for data controllers and processors. Data protection laws can also provide for exceptions for non-commercial uses by third parties. Over 100 countries have adopted data protection laws. Data protection frameworks and regulations are essential for managing the use of health data. An example is the EU's General Data Protection Regulation, or GDPR. Applies to citizens and residents of the EU, irrespective of whether the data controller or processor is based in the EU, and has global reach because it applies to non-EU citizens or residents if the data controller or processor is based in the EU. GDPR is designed to limit the data collected about an individual to what is necessary, allow collection of data only for listed legitimate purposes or with an individual's consent, notify individuals of data processing activities. It is intended to protect the data subject's right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. Article 22, GDPR. The GDPR provides additional protection for special category data, which is sensitive data that could reveal a person's racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, or sexual orientation, with protections extending to the processing of genetic data, biometric data, and health data. Health data are protected from processing under GDPR unless an individual provides specific consent or if use of the data meets certain exceptions, such as for health-related operations or scientific research. Even when exceptions apply, data processors and controllers must respect certain obligations. It should also be noted that domestic data protection legislation all over the world usually bestows special status upon health data. In other words, it is afforded a special attention and a higher level of protection. GDPR also introduced data portability, which is the right of individuals to obtain their personal data in a machine-readable format from one controller that can be sent to another controller. This could allow individuals to control their own data and share their data with additional entities. Data portability could decentralize the control and distribution of data and be a form of data management that fosters both oversight and innovation. Data protection regulations are enforced by data protection authorities which develop and administer regulations, provide guidance and technical advice, and conduct investigations. For example, South Africa introduced a data protection regime in 2020 with enactment of the Protection of Personal Information Act 4. This includes administrative fines that could exceed $500,000, civil cases, and criminal liability. Some governments have nominated supervisory authorities to facilitate the use of health data. For example, the United Kingdom established a National Data Guardian in 2014 for appropriate management of health data with respect to confidentiality and to improve the use of such data for beneficial purposes. In 2018, the entity was granted the power to issue official guidance on the use of data for health and adult social care in England. Community control of health data, data sovereignty, and data cooperatives. Measures have been taken to provide distinct communities with control over their data through the exercise of data sovereignty, or creation of data cooperatives. For example, several Indigenous communities have sought to establish control over their data through data sovereignty, including the Maori in New Zealand and First Nation groups in Canada. The Maori have introduced principles for data sovereignty that establish control over data, including protection against future harm, accountability to the people who provide data by those who collect, use, and disseminate them, an obligation for data to provide a collective benefit, and free, prior and informed consent, which, when not obtainable, should be accompanied by stronger governance. The Maori also recognise that the individual rights of data holders should be balanced by benefits for the community, and that in some situations the collective rights of the Maori will prevail over those of individuals. First Nations groups in Canada have outlined principles for sovereignty over their data with 4 elements. 1. Ownership of data. 2. Control of data. 3. Access to data. 4. Possession of data. Finally, a data cooperative gives people control over their data by storing data for the members of a cooperative. Data cooperatives allow secondary uses of data, with members of the cooperative deciding collectively how the data should be used, and members to set common ethical standards. You have now completed Unit 2 of Module 7, Elements of a Framework for Governance of AI for Health. In the next unit, we will look at data governance, guidelines and principles.